Attorneys love talking about their million-dollar settlements in personal injury cases, but what they don't tell you is what it takes to get them. If you want to know how to obtain a million-dollar settlement in a personal injury case, watch this video and I'm going to tell you all the secrets. My name is Phil Rizzuto of the Rizzuto Injury Firm. We represent clients who are injured through the neglect of others all over Long Island, throughout all 5 boroughs of New York City, Westchester, and beyond. Now, before we get started, let's clear up one big misconception about personal injury attorneys and personal injury cases. This is not the lottery. We do not live in medieval times where the remedy when somebody is wronged by another is taking an eye for an eye or a tooth for a tooth. We live in a civilized society, and in a civilized society, the only remedy available to compensate people for injuries and hold others accountable is a monetary one. It's a monetary remedy, and money is the only thing available. Now, the purpose and concept behind this is that money is supposed to represent what has been taken away from a person. Now, when we're talking about objects and property, that's easy because you figure out what you paid for it, you get the receipts. If it's something that's old, you take into account the depreciation. You can bring an appraiser to testify what something is worth. For instance, say it's a painting. You purchased a painting for X number of dollars. Maybe the painting has appreciated in value, maybe it has depreciated in value. That is easy to prove because you know what you paid for the painting. You can prove what you paid for the painting. And if there is a discrepancy between its value, you can bring in an appraiser who will tell you what the painting is worth. If it's your car, we see this all the time in car accidents. You bring your car to a repair shop. The repair shop gives you an estimate, and the insurance company has their own appraiser come in, and they give you an estimate, and you haggle over whose estimate is right, and you meet somewhere in the middle. But when you're talking about personal injuries and pain and suffering and emotional distress, it is not so easy to evaluate because people are different. How an accident affects you may be different from how an accident affects somebody else. A person's age needs to be taken into consideration. People heal differently. Somebody might heal much quicker than somebody else. They may make a full recovery from the same accident and somebody may not. They may be devastated and injured for the rest of their life. Now, in every lawsuit, including lawsuits that will settle for $1 million and above, there are 3 factors that are required in order to be successful. The first is liability or neglect. The second is there has to be an injury caused by the liability or neglect, and there has to be insurance coverage or a deep pocket that has the ability to pay for the damages caused. Now, liability or neglect means somebody caused an accident, and the definition of negligence is the failure to act as a reasonably prudent person would under the circumstances then and there existing at the time of the accident. Bad behavior or a bad act does not necessarily amount to neglect. You have to be able to prove that the person or the defendant, the one who caused the accident, failed to act in a reasonably prudent manner under the circumstances at the time of the accident. Now, when we talk about injuries or damages, we break them down into 2 areas, past and future. There are many components of damages. There are economic damages, such as lost wages, medical expenses, expenses for prescription medication, expenses for medical devices, expenses for diagnostic testing, expenses for household help, having to hire people to do the things around the house that you would normally do that you can't do because of an accident. So if you have to hire somebody to clean your house, mow your lawn, do your shopping, additional expenditures that you wouldn't have to pay for if you hadn't had the accident are compensable. Lost wages are also compensable. If the conduct is reckless or egregious, you may even be entitled to punitive damages, which is something available to punish the defendant for such horrific action. And then there's pain and suffering. This means what is the actual injury that you sustained as a result of the accident? How has this affected your life? What are you no longer able to do? What can you still do but are limited in doing? How has this affected you psychologically? And what documentation is there to be able to prove all of this? Being able to prove your injuries from an accident is so important because without it, you can have the worst injuries in the world but never be able to be compensated for it, let alone obtain a settlement of $1 million. You have to be able to prove your injuries and your pain and suffering with actual documentation. This includes medical records. This includes diagnostic test results such as MRIs or EMGs or any sort of nerve testing studies that show that you were injured. This includes x-rays, CAT scans, and it includes your own testimony as well as testimony from medical experts. It can also include testimony from economists regarding your future damages and calculate what your past damages were. And that would include medical expenses, lost wages, and how this will affect your ability to pay for things in the future. It may also include testimony from a vocational expert who will testify as to what you are no longer able to do and what jobs are actually available to you under your current circumstances as a result of the injuries you sustained from an accident. Now, the third element is a deep pocket who has the ability to pay for the injuries they caused, and that is usually an insurance company. When we're talking about insurance for defendants who cause accidents and injuries to other people, there are several factors that need to be taken into consideration. First and most important one is, what are the policy limits? If you are operating a vehicle in New York State, the minimum amount of insurance required is $25,000. Some vehicles have more than $25,000, and there is no limit as to the amount of insurance somebody can get. If you're involved in an accident on somebody's property, especially if it's a commercial property, the insurance is much higher, and usually premises liability insurance is at least $1 million. Sometimes it's less, sometimes it's $500,000, but usually those are bigger policies. A commercial vehicle, if you're involved with an accident with a UPS truck or a FedEx truck, those policy limits are also often higher. But if the policy limits are minimal and not enough to compensate someone for their injuries from an accident, you need to have an attorney that has the ability to make a determination if there is more insurance coverage available. Is that all the insurance coverage there is? And there are steps that need to happen in order to make that determination. The first one is to get an affidavit from the defendant stating there is no insurance coverage available. In our day and time, there is no such thing as an asset search anymore. You are limited in what you can find out about the assets that someone owns, but there are ways you can find out additional information. Another important factor is, does the insurance policy cover the incident? So we have a case where our client was attacked by someone else's dog, but that particular dog is excluded from the person's homeowner's policy. That is a problem. So if you have catastrophic injuries, if you have injuries that are worth millions of dollars, but the only available insurance coverage is $25,000, you're going to be out of luck, because people who only have $25,000 of insurance do not have assets or the ability to pay for such catastrophic injuries. Now that we've spoken about the three factors that must exist in every lawsuit in order to get a great recovery, how do you get $1 million settlement? How do you get a 7-figure settlement? The first thing you need to know is that there is a difference between a settlement and a verdict. A verdict is a decision rendered by a jury. In New York State, in a civil case, it's 6 people that hear the evidence at a trial and come to an award. This happens because a settlement has not been reached and the parties disagree as to the value of the lawsuit. A jury verdict can be appealed. So if you can't settle the case and the insurance company forces you to go to trial because they're taking an unreasonable position or you're taking an unreasonable position, the defendants can appeal the verdict. So sometimes even if you win, you lose. There are a few grounds the defendants can appeal from. If the judge made errors during the course of the trial, they can make an appeal and get the whole verdict set aside. If the verdict is too high, they can appeal it as being excessive, and the trial judge, him or herself, or the appellate division can reduce the award. Conversely, if you go to trial and get an award that's too low, you can appeal it and ask for additure. That means you can ask the court to make it higher. Settlements are good for several reasons. First, you have closure. You know what your settlement will be. There is certainty, and there is no risk of an appeal. Once you agree to a settlement, the money is coming to you soon. You are not at the mercy of 6 people to render a decision that you may or may not like. You don't have to wait to find out if the defendants are going to appeal the decision. You don't have to worry about scheduling experts. You will get the money within a few weeks of signing the settlement papers. But in order to get $1 million settlement or more, you need to have a case that warrants $1 million settlement. So your case needs to be evaluated, and you need to have an attorney that knows what they're doing and knows how to properly evaluate a case. So like I said earlier, there are 3 factors that are needed in order to be successful in order to have a $1 million case. Right? We need liability, we need injuries, and we need insurance coverage. So let's look at them in reverse order. The first thing we need to find out is, what is the available insurance coverage? Who is going to pay for the damages caused by someone else's neglect? If the insurance policy is only $25,000, like I mentioned, and your injuries are worth millions, you're out of luck. I once had a case where somebody was operating a vehicle, they went through a red light, and they struck a man, stopped at the light, sitting on his motorcycle. The man lost his leg. He was 55 years old. He was out of work for a year. The medical treatment was expensive. The prosthetics were expensive. He had to reconfigure his house and make it handicap accessible. The damages were worth millions, but the driver driving only had $25,000 in insurance coverage. There was no more. So in order to get a $1 million settlement, there has to be a deep pocket. Somebody has to have the ability to pay for it. Now, once you know there is available insurance coverage, you need to properly evaluate the case. So first we look at, how are we going to prove liability? What evidence is there that favors the client's version of how the accident happened? The client's statement is number 1. Police reports, photographs of the vehicle, the points of impact, photographs of the accident location. If it's a premises case, photographs of the defect. We need to see what witnesses there are. Is there any videotape surveillance of the accident or of the defect? Sometimes medical records even help us prove liability. But one of the best nuggets available to an attorney in proving liability, the smoking gun, so to speak, is the defendant's own version of what happened. If the defendant admits liability, it's a home run. Now, after we have taken into consideration all the evidence we have in order to prove our liability case, we come up with an evaluation. Usually it is in terms of a percentage or our chances of winning. It is possible to get a $1 million settlement on a case where liability is tough and there is a small percentage of liability, such as 10%, if the damages are extremely high. So the next thing we need to take into consideration is the injuries and or the damages. We need to look at what actual evidence we currently have and what actual evidence we will need in order to prove the injuries and the damages. As I mentioned, in a motor vehicle case, we need to be able to prove that the person who is injured sustained a serious injury. So what we need to take into consideration is, 1, the nature of the injury, the person's age, the treatment they've had, the extent of the treatment that they will require in the future. What do the actual medical records say? Did the doctors put in the records what the plaintiff is claiming the doctors are saying? We need to look at the actual economic impact this accident has had on the person's life, on their activities of daily living, on their job, on their actual out-of-pocket expenses for medical treatment, medical devices. We need to look at the economic impact this will have into the future. And taking all of this into consideration is not enough without having the evidence to prove it. In some cases, we will hire an economist or somebody to perform a life care plan of the person. And the economist will look at the person's earnings, what they are no longer able to do, what their past loss of earnings are, and how this is going to affect them into the future as far as their life expectancy goes and as far as their work life expectancy goes. Over the next several years, how many doctor visits are they going to have? What diagnostic testing is going to be required? What physical therapy will be required? What devices will they need? Will they need to buy canes? Will they need to buy prosthetics? Will they have to pay for these things? How frequently? And what will it cost over their remaining life expectancy? So once we look at all of this and we take it all into consideration, we come up with an evaluation of what we think the injuries, exclusive of liability. We don't take into consideration liability at this point, but we just look at what the value of the injuries are and what they potentially could be. So as I said earlier, it is very possible to have a case that has minimal liability, but if the injury evaluations are extremely high, then it could be a $1 million settlement. But you can never have a $1 million settlement if you have 100% liability and the injuries are minimal. So let me tell you about a couple of cases we recently settled for over $1 million. The first case involves a driver. He was 33 years old. He was involved in an accident with another vehicle. The other vehicle crossed a double yellow line and hit him head on. The other vehicle was claiming they had a medical emergency, which is a defense, and if they can prove it, then there is no case. Our client was 33 years old. He had injuries to his neck and back, herniated discs that were impinging on his spinal cord. He missed over 3 months of work, so we were able to meet the serious injury threshold, but the doctor testified that the injuries were permanent. He was in a lot of pain, and they were going to affect him over his life expectancy, which I approximate to be 47 years. His activities of daily living were impaired. His doctor said the nature of the injuries were going to cause him to have an early retirement, and although he was able to resume his job, he was able to resume it on a limited basis because he was a laborer. So he was working, but he was working with pain. He had to take more time off than he normally would, and the injuries were going to force him to have to retire earlier than he normally would. Approximately 10 years earlier is what the doctor said. So we hired an economist to calculate the numbers. We hired a life care planner, a doctor that performs a life care plan report to estimate what the cost of MRIs would be over the next 47 years of his life, the cost of treatment and physical therapy, whether he would require future injections in order to alleviate the treatment, and the possibility that he would eventually have to have spinal surgery. Now, liability in this case was clear-cut in a way because we were either winning the case or we were losing the case. There was no comparative negligence and no splitting the baby on this. So we had to figure out what is our percentage of winning the case, and we looked at what proof did the defendants have to prove their medical emergency defense. And the defendant driver died, so he was unable to testify. The medical records didn't really support it, so the defense attorneys were basically hoping that we would presume, because he died shortly after the accident, that it was a medical emergency. The insurance policy limits were $2 million. So we took all of this into consideration. We looked at liability. Again, liability was either going to be 100% or 0%, but our chances of winning were very strong. I would say our chances of winning were 75 to 90%. Injuries of this nature are tough to evaluate because they're soft tissue, and insurance companies don't like to pay on soft tissue injuries where there are no broken bones or no surgery. But the client had continuous treatment. His injuries were well documented. He was young, so the insurance company's argument that they were pre-existing or degenerative really wasn't a strong argument, and they knew it. We had an economist to calculate actual future out-of-pocket expenses as well as his past out-of-pocket expenses, and when you work up actual numbers and you show that they are potentially high, that helps give credence to the value of the pain and suffering in the actual injuries. So when you take into consideration the time value of money, because we settled the case a year or two or possibly 3 years before it would come up for trial, you calculate the risk reward. The reward was potentially another $200,000 as opposed to losing $1.8 million if a jury believed that the medical emergency defense was valid. And we take into consideration the client's risk tolerance. When we received an offer of $1.8 million, there really was not much to think about. And you need to keep in mind, the offer did not start at $1.8 million. I believe the initial offer was probably somewhere around $25,000. And it was not until after we gathered the medical documentation, our client testified, we got the medical reports, we had the economic expert, we had the life care plan, did the insurance company eventually come up to the $1.8 million. And to be honest with you, they didn't want to pay more than $1.5 million. They were stuck on $1.5 million for the longest time, but we went to mediation. The mediator helped us get over that threshold and closer to $2 million, and we were able to resolve the case. And more importantly, the client was very happy with the result. The second case I want to tell you about is a woman. She was about 45 years old. She tripped and fell on someone's property. It was a pretty significant defect. The property owner knew about it. They didn't repair it. And her injuries were also to her neck and back. She had extensive treatment. She tore her rotator cuff and her shoulder, and the policy limits were $1.2 million. Again, we were able to show there was a defect. The defendant, the property owner, had notice of the defect and failed to correct it, and we were able to get the medical documentation to support the client's injuries, including her economic damages. Now, in this case, the policy limits were only $1.2 million, which is what the settlement was. Now, the third case I want to tell you about is a funeral home neglect case. Our client's father died at his house. When the body was discovered, it was taken to the medical examiner's office in Brooklyn. My client hired this particular funeral home to perform a cremation of his father. The funeral home never contacted the medical examiner's office to get the body to perform the cremation. In New York City, you only have 30 days to get the body from the medical examiner's office. Otherwise, they will dispose of the body. How do they dispose of the body? They send the body to Potter's Field. My client kept contacting the funeral home and asking about the status of their father and the cremation, and they kept getting the runaround. They said it takes time, it takes several months, we're working on it, and they lied to my client, making my client believe that they had the body and it was being cremated, but it would take a while to get the ashes. The client contacted our office. Performed an investigation. We found out that the funeral home never obtained the body from the medical examiner's office, and the medical examiner's office sent the body to Potter's Field to be buried in an unknown grave. After several weeks of extensive investigation, we were able to track down the body and have the body properly cremated. Obviously, we sued the funeral home. So in this case, I think liability was pretty clear-cut. Not only were they negligent, we had a breach of contract claim. My client hired the funeral home to perform a service. They didn't do it, and they basically lost my client's father. As damages go, this is a unique situation because there is no medical treatment. There is no physical injury. There is no doctor's appointments. There is no testing. What does exist is a claim under the law known as loss of sepulcher. Loss of sepulcher exists when the next of kin is deprived of the right of burying their loved one in the manner in which they desire, and damages are presumed. These cases are rarely litigated, and there is almost no track record as to evaluation or value of these types of cases. There was plenty of insurance coverage because the funeral home had a policy that was a global policy of $10 million that covered all claims within a certain time period. The problem with this particular funeral home is there were a lot of claims against them. Their initial offer was in the low five figures. It might have been $10,000, $15,000. However, we felt liability was strong. We felt the damages in this situation are immeasurable. I mean, pain and suffering in and of itself is immeasurable, but how can you place a value on a man who hired a funeral home, cremate his father, and they lost his body, and he didn't know where his father was located for several months? Worse yet, they lied to him. After several years of litigation and motion practice, we were able to settle the case for $1 million. Some of the reasons we were able to settle this case for $1 million are: one, our law firm is familiar with handling funeral home neglect cases. We have a lot of these cases, and we have a lot of these cases against the very same funeral home that settled this case with us. Another reason, as I had alluded to earlier, is insurance companies hate risk. They hate risk, and they know we were willing to go to trial. We have a case where their conduct was reckless and egregious. We had a very strong argument to get punitive damages. Liability was evident. They were hired to do a job. They lost my client's father. They lost him, and his father was sent to Potter's Field, and it took us several months to locate him. The funeral home did not want 6 people deciding this case. So why did our client hold out for more money? Well, there were a few reasons. First, $1 million is a hard settlement to turn down. It is almost as if somebody is offering you $1 million and you are saying, you know what, I'm going to take the money, I'm going to go to Atlantic City, and I'm going to put it on red or black, and if I lose it, well, I lose it. But if I win it, then I'll get $2 million. So there was always a risk. And although the risk of the client getting nothing was almost non-existent, there was a risk that they would get less than $1 million. There are people that have no emotions, no empathy, no sympathy, and they believe that when you're dead, you're dead. What does it matter? Body was going to be cremated anyway. So why should my client receive $1 million? That's a possibility. There are people out there, and some of you may be watching, that think our society is litigious and there are too many lawsuits and that every lawsuit is frivolous. They may see this as a money grab and not be so sympathetic and not believe that the funeral home did anything wrong. So there is no guarantee that a jury would have awarded my client $1 million or more. They could have awarded my client less than $1 million. The best cases are when the insurance companies make it easy. And that's what they did in this case by lowballing us initially with a $10,000 or $15,000 offer and nickel and diming us until we got closer to trial. It was not until we were on the trial calendar and a trial date was imminent that they get serious about the negotiations. And you can tell when someone is nervous and someone is anxious to settle a case because the calls now get more frequent. They start increasing the offer by a significant amount of money. And I guess one of the reasons they call us attorney sharks is because we can smell the blood in the water. So at this point, we want to push the insurance company to their limit, to their very top limit. Again, this is a case where we have the leverage, where we have liability, but when you have conduct this bad, I really believe the jury would have done the right thing and would have awarded a 7-figure verdict. And you know when you tap out, you know you've tapped out and you've got as much money you can get when the insurance company is locked on a number. So they were locked on $750,000 at one point for the longest time. And as time grew and as the case progressed and we got closer to trial, they got to $900,000. And that was really their bottom line. We maintained for the longest time that we would take $1 million to settle the case. We really were not negotiating off of that number. And when we said no to $750,000, we said no to $900,000. We just said we're going to trial. If you don't want to pay the $1 million, once we start selecting a jury, we're no longer going to accept $1 million to settle the case. After speaking with management and all sorts of people, they finally relented and they decided to pay $1 million. So in addition to having liability, damages, and insurance coverage, you need a skilled attorney. They need to be skilled in handling these types of cases. They need to be skilled in negotiating, and they certainly need to be skilled in being able to try the case. Not all attorneys are created equal. There are attorneys out there that do real estate, commercial transactions, landlord-tenant work, and they think personal injury cases are the lottery. They think if they get a personal injury case, this is it, they're going to retire, this is the big case everybody's been waiting for, and they won't have to work anymore. That is completely a fallacy. The attorney needs to be skilled, and they need to handle these types of cases, period. The insurance companies know what attorneys handle these cases and what attorneys don't. If you hire an attorney that does not handle these types of cases, the insurance company, they will lowball you and they will never, ever, ever give you a fair offer on the case because they know your attorney doesn't have the ability to handle it and they're just looking to make some quick money. The insurance companies also know what attorneys will go to trial and what attorneys won't. There are firms out there that just handle cases, they'll push them along, they'll get the best settlement they can, and that's it. And when the insurance company pushes them to go to trial, they have to do one of two things. They have to accept a settlement that is below fair market value, or they have to find somebody who's capable of trying the case. Believe me, the insurance companies know what attorneys will try the case to a verdict. I know because I used to do insurance defense work, and my clients would hold back money that they should be paying because they would say they're never going to try that case, and they were right. So hiring an attorney that knows what they're doing, that is willing to go the distance, is as important as everything else. Because if you don't have the right attorney, no matter what your liability is, no matter what your injuries are, no matter what the insurance coverage is, they're not going to be able to put it all together and get you the best result. They're going to get the best offer they can and move on. And the last thing that is required in order to get $1 million settlement is risk tolerance. As I told you, as I mentioned in the funeral home neglect case, at one point the offer was $750,000. That is a lot of money to turn away. That is like taking $750,000 and going to Atlantic City and putting it on red or black with the hope you will get more. But my client had the right attorney. We knew what we were doing. The client trusted us and they valued our opinion. And we were all in agreement to hold out for the $1 million because that was the right thing to do. And that was the right settlement amount on this particular case. But there are some clients that have zero risk tolerance, and no matter how skilled we are or how much they believe in us, they want the case to be over. They don't want to take a chance, and they want to walk away with the money sooner rather than later. So not only do you have to have a high risk tolerance to get $1 million settlement, sometimes it's not that high, but there is a risk tolerance when serious money starts being offered. Now let's sum it up. What do we need to get $1 million settlement? We need deep pocket or insurance coverage of at least $1 million or more, and we need to know how to locate it. We need to have the type of injury and damages that warrant a settlement of $1 million or more, and there needs to be liability in proportion to the damages that would warrant a settlement of $1 million or more. You need to have a skilled attorney that knows what they're doing, who can negotiate, willing to go to trial, and could get these cases resolved for $1 million or more. And you need to have a high risk tolerance or some risk tolerance to hold out when the offers get enticing. If you have been injured through the result of someone else's negligence, ring Rizzuto at 800-666-5555. We can help. If we can't answer your question or help you, we will find somebody that can.